Good morning, landlords. It's Ernie Garcia, landlord attorney. I am happy to meet with all of you today. I'm excited to share this topic with you that has to do with allowing a tenant to renovate rental property. Should I allow my tenant to come in and change what I've set up? Well, I'm going to give you some pointers, a few things to think about whenever you're considering this option. We're going to start by talking about what is in your lease. If your lease doesn't naturally address the rights of the tenant and the duties and obligations of both the landlord and the tenant, particularly as it comes to repairs, then your lease is deficient. It's defective. It's not gonna cut it because these issues inevitably will come up. And you wanna make sure that you've got a rock solid lease that every single time will protect your interests, particularly when it comes to the rental property and the rights of the tenant to alter it. A really great lease is going to prohibit absolutely any alteration whatsoever by the tenant on the premises. And this is a good rule of thumb. You always want an absolute ban on alteration. And generally speaking, the text in a provision like this will say the tenant is not allowed to alter the premises in any way without the express written permission of the landlord. And this is extremely important, that without something in writing from you, they never had the right to touch the walls or the cabinets or the flooring. I once had a situation where a tenant built an entire other room in the home, didn't ask, just started building, didn't get permits, just started building, didn't check with the owner as to the quality of the work or the quality of the materials, they just started building. And so if you find yourself in a situation like this, the first place you're gonna look is your lease. Now, when it comes to leases, one of the great things that I like is the idea that the landlord gets a lot of control when it comes to the lease and the kind of lease that they use. If you find yourself in a situation where your lease is a bit lacking, good news for you. Right now, in the month of September, we are running a special. And in that special, you're going to find that you can order a lease from us at a discounted rate during the rest of this month only. So for the rest of the month of September, you can find a $100 discount on our normal lease rate. Regularly, we sell it for $650. We'll sell it for $550, and you get all of the same great bonuses that come with it. The lease itself that you can tailor and use over and over and over again anytime you need it, along with all the necessary addenda that you're going to need to manage your property well. I also have a Spanish translation for reference. It's not the copy that you would sign, but if you have a Spanish-speaking tenant who would like to see what the terms look like in Spanish, they can see an explanation of what the terms are in Spanish. But the best thing about this lease is that you get to use it over and over and tailor it specifically to your needs. In fact, part of the special and part of the package that we always sell to landlords comes with a 30-minute consultation with a licensed Texas attorney. You and I can go over this lease together and make sure it pops. Make sure that it says the kind of stuff that you need 100% of the time and is tailored specifically to the needs of your particular property. If that's you and you find yourself in need of a lease, we'll have links below that you can click on to check out that offer. You've got your lease, and hopefully you've got a rock solid lease, and if you don't, you know where to get one. But your lease should have an absolute prohibition. The question then is, if there is no prohibition, does your tenant have an absolute right to just begin work right now? I would still say no. It's a little tougher to prove that they had any kind of other restrictions, but you can still go in there and say, no, you're not allowed to alter my property. But what if they ask and they say something to the following effect? Landlord, I am willing to pay 100% of the improvement to your property. I want to install flooring, or I want to paint the baby's room, or I've got these great fixtures that I love and I'd like to install them in all of the bathrooms. What do you do? Well, the first thing to consider is, how does this make your property better? Because you might find that the color scheme or the quality of the work doesn't measure up to the rest of the house, and certainly wouldn't have been something that you would have chosen. Remember, these people very likely will not be living on the property forever. Instead, it's very likely that soon they will transition off the property. And if that's the case, but their alterations, their changes, their improvements have stuck around, now you have to deal with them. And so you have to ask yourself, what is the potential cost for me in the long run if they make these changes? One way to ensure that you won't have to incur any cost is an agreement both to build it up and to take it down, or to return the property to its original condition at the end of the lease. So this potentially is one way that you can ensure that you get your property back just as you gave it to the tenants, in the same or similar condition. But there's risk here. What if they pay $3,000 to make whatever changes, and then at the end, skip town? And when it comes to it, none of these changes go with the flow of your house or with your taste, or are likely to generate new tenants who are happy with these alterations, ultimately costing you money to return the property back to its original condition. If you find yourself in this situation, you're going to be in a bit of a pickle having to deal with these additional costs when you, again, didn't have to. So one of the risks is, look, it cost X to get the property back. How do you resolve for those future costs, and how do you ensure that the tenant will cover those costs? Well, one way to do it would be to modify your lease to include additional amounts in the security deposit. If, for example, tenant A says, I want to do X, Y, and Z, you can go and secure an estimate from a contractor who says, well, if they do X, Y, and Z, and you want me to restore it to the original, I'd bill you this number here. And so you can use that as a reasonable basis of what it ultimately will cost. And you can enter into an agreement with your tenant that if they cover the costs from a contractor that you select, again, you've got an estimate for that work. Once the tenancy is over, if they'll cover those costs to rehabilitate the house back to its original condition, and they're willing to pay it, then again, when they get that done at the end of their tenancy, you might return that portion, as you are required to do with every security deposit, return that portion to the tenants in exchange for that work at that future date. So one way to protect yourself is to have the tenants pay additional security deposit to make sure there are funds in the security deposit specifically for rehabilitating the property. Again, don't just say, well, I'll just take it out of the security deposit. That's not a good strategy. That reduces your security. Instead, what you want to do is increase your security by saying, we'd like to add this reasonable amount that it'll cost to restore the property back to its original condition. On that stipulation, yes, I will agree to this alteration. Now, remember that whenever you allow a tenant to do the work, they're going to choose the material and they're going to choose the contractor unless you step in and say, no, I must approve the material, I must approve the contractor. And so if you are going to allow this work, make sure that you have a say. You don't want the tenant to have carte blanche in a situation like this, because ultimately they may choose in a way that opposes your interest. You want to protect the value of your property, and you want to make sure that whatever gets done actually improves the property, and if not, that it doesn't result in immediate harm. You certainly don't want somebody to come in who's not a licensed or trusted contractor who starts a job, doesn't finish, and then puts a lien on your property. That's the last thing you want. So you want to make sure that you use your own trusted people, maybe suggest people that you've used before to the tenant, and hopefully they decrease that risk of liability or ultimately harm to your property. So it's a complicated topic. You know, we want to be helpful and accommodating to the tenants, and that's always a good thing, but it has to be within reason and it has to make business sense. Do you just allow any tenant to do any alteration to the property? No, that's never a good idea. But if you are going to allow it, make sure that you have specific guardrails and specific protections, like an increase in the security deposit, to to make sure that you can return the property back and to minimize the possibility that you're going to incur losses for allowing the tenant to make this alteration in this way. Hello, is it standard practice, question 1 reads, is it standard practice for the landlord to increase the security deposit and last month's rent when there is an increase in annual rent? So there's a couple of things in this question that I want to address. If you're asking, what is normal? Well, so this happens from time to time where the rent is modified, but a lot of times the security deposit is left untouched. I would say that yes, you can increase rent and give a notice of rental increase, even unilaterally, with an appropriate notice, either 30, 45, or 60-day notice, depending on what your lease says. But alterations of other terms are probably going to require something more formal. So if you're going to make changes like this, you always want to do it in written form. So if you have a form that addresses alterations to an original lease, it has to be signed by all of the original parties. And yes, you can all agree to these terms. However, if your tenant says, nope, no way, that ain't gonna happen, then you have to ask yourself whether this is a contract you want to continue, whether this is something you do want to renew, or something that you do want to alter in this way, especially if your tenant is hostile to this change. So first and foremost, understand between the parties what everyone is willing to agree to. Second, make sure that it's done in a written form that adequately addresses your concerns. If you're going to increase the rent and the security deposit, then make sure it is clear in that either that amendment or that newly drafted lease that those are your terms. Now, in this question, it mentioned something about security deposit and last month's rent. And just as a sidebar, this isn't exactly what today's topic is about, and I don't think this was the purpose of this particular question, but I do want to address it. If you're taking security deposit and last month's rent, you're really just taking a bigger security deposit. I wouldn't distinguish between the two. I wouldn't say, well, I'm holding this amount as rent for the very last month, and I'm holding this amount for the security deposit. Put it all in one bucket, make sure it's just security. That makes you the most secure. Because, and this happens, you get to the end or near the end of the lease, and now because you're holding rent, how it's applied sometimes gets messy. But if it's all security deposit, then we know that the rules in your lease probably say so, and state law definitely says so, that security funds cannot be used for the purposes of rent. They're there to secure the landlord from things like damage to the property, other fees, and unpaid rent after the tenancy is over. So my preference is never to have prepaid rent other than the rent that goes at the beginning of each month, but not that last month's rent. If you need it because you desire additional security, just call it a security deposit. Don't create a fiction where you're holding two separate things in two separate accounts. It's much easier and much cleaner for you just to say, I'm going to take a 2-month deposit. That's common. And again, if you're modifying the lease to increase that security deposit and increase the rent, then yes, I would address both. But typically, I don't favor collecting a security deposit and prepayment of the last month's rent. Again, just connect it all, put it together, one thing, security deposit. Okay, so question 2. I'll be filing an eviction on Monday. What do I need to do to make sure that it goes smoothly as possible? What are some things I should be on the watch for? I'm the landlord and rent out rooms in my house. Well, there are a couple of things. Now, you've already filed, so I'm not going to get into what you should have done pre-filing. We're going to presuppose that you filed everything appropriately. You sent all of your notices in accordance with state law, and you are ready to go. So what sorts of things should you look out for? Number 1, you may have been given a trial setting by the court, but call the court the day before the trial to make sure that the tenant has been given notice of the trial setting. State rules say that unless the tenant has at least 6 days of notice for that trial setting, that the court should reset the case to allow the tenant an opportunity to prepare for the trial. So it's possible that a tenant gets served, say on Monday, and trial is later on Thursday. That's not enough time under the rules. And so the court may have reset the case and mailed you notice, and you show up to the court and they tell you, nope, come back in a week or come back in 2 weeks. We had to reset. So one thing you might want to look out for is to make sure that your case is even going and that the tenant has been properly served. Next, if you're asking, well, how can I make things go smoothly for myself? Well, one easy tactic is to make sure you go fully prepared. Take a copy of your lease, take a copy of all of the notices, take a copy of your rent ledger, any photographs or invoices, any documentation that you might need to prove the facts of your case. You don't want to rely on what was filed and show up empty-handed and then be questioned about any one of these things. That's going to leave you flat-footed and potentially risk losing the case when you've otherwise have strong facts. Show up to the court fully prepared to demonstrate everything that pertains to your case, the lease, the notices, any photographs, any receipts that you have. If you accept cash payment, for example, you better have a receipt book and proof that you've handed receipts over to your tenant. That's a big one. I don't typically recommend that you accept cash payment, but if you do, you must have a receipt book and proof that you've given written receipts to your tenant. What else can you expect? Well, if the tenant shows up and the tenant is going to contest the lawsuit, then one thing you should be ready for is the potential for mediation. Many courts will sometimes say, you know what, while you're here and you're waiting for the rest of these cases, why don't you step out into the hall? Sometimes courts have mediators there who are volunteers who are willing to help parties enter into a settlement agreement if settlement is even possible. And so be prepared if your tenant shows up and if your court assigns you to mediation or requires you to speak, to have reasonable terms of settlement in mind if that makes sense for you. If it doesn't make sense and there's no way you would ever keep this tenant because of X, Y, and Z, make sure that you can present a cogent explanation to the court. They've destroyed my property and caused $10,000 or $15,000 worth of damage. I would otherwise keep them, but I cannot trust them with my property. Or, Your Honor, at this point, they are 3 months behind in rent, and my intention is to get out of the landlord business. I would like to sell the property, and so I would like to recover possession of the property to do that. Perfectly reasonable basis to not settle and to proceed with the eviction. So make sure you show up prepared to address a tenant who will contest your eviction. And then finally, make sure that when you show up on time. You can lose a case so easily by being 5 or 10 minutes late. I see it happen all the time, and there's no reason for it to happen. Now, a case being dismissed like this is not the end of the world. It can be reset, but you got to get to it quickly enough to make sure that you can reset it with that court. Otherwise, you're going to have to start the whole thing over again. So you want to help yourself, make things go smoothly, show up, know where to go, when to be there, and what to have with you in order to present your eviction case.
So same person as question number 2.
Okay, so here we have an additional question. Once evicted, what is the best way to collect late rent, fees, and etc.? Well, so this is a little bit complicated because the eviction will not encapsulate things like late fees or repair costs or HOA fines. None of that stuff is included in an eviction judgment. But let's say you've evicted a tenant and you want a judgment for X, but you've got additional damages in Y. And so you can go after X by abstracting the judgment and creating a judgment lien. So now in the future, if that tenant ever seeks, for example, to buy a house, and they've got a judgment lien that you've established because you know the last 3 of their social, the last 3 of their driver's license, and the date of birth, information that you gathered from the application process, you can file an abstracted judgment and record it with the county record. So again, if in the future they're buying a house before title is going to issue, I guarantee you, you're going to get a call from somebody saying, hey, I've got this judgment lien on person X. We'd like to get it released. what is it going to cost to pay off this judgment? So that's one way to help collect. But with regard to why those damages and the amounts that could not be included in your eviction judgment, how can you collect those? Well, there are various collection agencies that will claim to give you a portion of whatever they collect, and they keep the balance. I've seen very little to no success when it comes to companies like this. So then the question for yourself is, does it make any sense for me to go after the tenant for Y and potentially X as well, to go after them more offensively? Well, you could potentially file a separate lawsuit and sue them in another court. But I always ask landlords to ask themselves these two questions. Number one, can you find the tenant? Do you know where they live now? Or do you know where they currently work? If you can find the tenant, then you can serve them, and then you can proceed with your lawsuit. However, the second question is probably a little more important. So if you can find them, great. But this is the second question, can you reasonably expect to be able to collect this money from these tenants? And if you know these tenants simply don't have the money, then I would preserve the abstract, because if in the future it turns out they do have money and, for example, they're looking to purchase a house, you can collect that. But if they presently don't, do you want to risk filing a civil lawsuit, going after somebody who presently doesn't have a reasonable capacity to pay and presently does not have, in your mind, a reasonable opportunity to or a desire to pay? Then it might not be reasonable for you to go after them for these additional fees. Maybe be satisfied with your eviction judgment and just let the rest of this go. However, if you have someone who does have a good job, who does have assets or accounts, who does have the means to pay these judgments, then absolutely you want to go after them. If you know where they are, so you can serve them, then file a subsequent civil claim to collect all of their damage to the property, to collect all of the fees owed under the lease, and to collect your court costs, interest, and any additional fees that are due to you for breach of this particular lease. So collection can be complicated, but the key is, can that tenant actually pay what is owed? And so it looks like that's it for questions. If you have additional questions, I strongly recommend that you leave those below. I personally review these and I'm happy to answer them, and look forward to additional sessions. Every Friday I'm looking to be either on Facebook or on YouTube live to answer questions just like this and give you more content that I know is so useful to you. If you are interested, as I mentioned before, in beefing up your lease and making sure you have a rock solid document, that foundational document, we encourage you to check out the link below to take a look at the offer that we are offering just for the month of September. If you are interested in getting a new lease, $550, it's $100 off our normal cost, comes with a ton of additional incentives that we hope you use and benefit from. Until next time, landlords, happy leasing. I'll see you again soon.